Good morning, ladies and gentlemen. Let me welcome everyone. A couple of ground rules. Everything we say here is confidential, so you don't have to worry about it coming back and bothering you at a later time. And when we break into our private sessions, that which you tell me is also secret. And I will not share that with the opposing party or parties unless you grant me authority to do so. Now, the beautiful thing about mediation is today, all parties have control of this case. And when I say control, I mean you can settle it any way you want to. You can flip coins, you can throw darts, doesn't make any difference. Any way you want to, you can settle this case. Now, do you have to settle it? Of course not. Each of you has the absolute right to go down to the courthouse and have your day in court. But the problem with that is while today you have control, tomorrow you have none. And the control rests in the hands of, at times, 6 good people, that's your jury. At other times, a bench trial, just the judge. And you have absolutely no control over what the rationale is. And by the way, when I look around the table here and I see your attorneys that represent you, they are outstanding lawyers. And they live and breathe as as I call them, legal warriors. They go down to the courthouse and they do battle with the oral and written word for you. And they'll tell you that they've had cases that they absolutely, positively knew they were going to win. They had the facts, they had the law, they had the witnesses, and guess what? They lost. On occasion, they actually lose. And on the other hand, you could ask them, well, you ever had a case that you knew you were going to lose? He says, oh, yeah, I've had those too. And I knew I was going to lose. And lo and behold, the jury came back for me. Now, those are unusual circumstances, but they happen, and they do happen. So it behooves both parties to assert yourselves and to compromise and to settle the case. Now, the plaintiff goes first. I should say, let me back off. How these proceedings work is that each of the attorneys are going to make an opening statement. That's where they can talk directly, eyeball to eyeball, to the opposing party and tell them what the facts and what the evidence is going to be. And it's exceedingly important that each of you listen with an open mind. So Mr. Smith is going to be able to is going to tell you, the opposing party, what the benefit of his case was, and Mr. Jones will say, will direct all of his evidence. And by the way, if it doesn't sound good here today, this morning, it's not going to sound any better down in the courthouse in the weeks and months to come. So, if you listen with an open mind, like your jury will, because they're going to do the very best they can to see that justice is served, and if you listen with an open mind, because they will, you'll have the very enviable opportunity to evaluate the risks in not compromising and not settling the case. As I said before, the plaintiff goes first. Not that we love the plaintiff any more than the defense, but the plaintiff's got the burden of proof. Plaintiff's got to get the ball just over the 50-yard line, convince the jury a little more than half. If you do, you'll prevail. If it's equal or less, then it will be a defense verdict. So the plaintiff has the burden and privilege of going first in all stages of the proceedings, and accordingly, Mr. Romano, would you care to go forward with your opening statement on behalf of the plaintiff?